This is a Harlan Institute FantasyCast for M.B.Z v. Clinton. M.B.Z v. Clinton is a case that started with one boy's birth certificate and ended up raising tough questions about what kinds of power the Constitution gives to the president. In October of 2002, Menachem Benjamin Zivotofsky was born in West Jerusalem. His parents, both American citizens, sent a formal request to the State Department requesting that their son's birth certificate list his place of birth as Jerusalem, Israel. The State Department refused the request, stating that their official stance was not to recognize any nation's ownership of Jerusalem, as this has been a source of violent conflict between Israel and Palestine. The Zivotofskys, on behalf of their son, sued the Secretary of State, citing a recently passed law that gave American parents the right to have Israel listed as their child's place of birth on birth certificates in situations like this one. However, when President George W. Bush signed the law in question, he issued a signing statement, saying that he would not be enforcing the part of the law that dealt with Jerusalem, because it was an unconstitutional interference with his executive power to make foreign affairs decisions. The district court dismissed the case, holding that the president's foreign policy decisions fall within the scope of the political question doctrine, which means that it involves issues that the court cannot properly resolve. The Court of Appeals agreed, also dismissing the case, so the Zivotofskys appealed to the Supreme Court. When the Supreme Court decided to hear the case, they isolated two issues. First, does this case involve a political question that cannot be heard by courts? And second, was Congress's attempt to legislate about the ownership of Jerusalem an intrusion on the president's constitutional authority to make foreign policy? Thank you for listening to this FantasyCast. For more information, please visit harlaninstitute.org or fantasyscotus.org.